There's a question that's come in about how family court and criminal court judges deal with a parent who is only supposed to talk about the children but abuses that right and instead tries to discourage or intimidate a witness from testifying in a criminal case. All right, my name is Mike Dickerson. I'm a prosecutor here in Las Vegas, Nevada. Here with me today are John Abel and Emily McFarling. I'll let you two go ahead and introduce yourselves.
I'm John Abel. I'm a longtime 18-year LV and PD police officer, and then I do government affairs for our union for the Las Vegas Police Protective Association.
And I'm Emily McFarling. I am a 20-plus year family law attorney, and throughout my practice, I've done a lot of specialized work in parental abduction, international parental abduction, working with the U.S. State Department, and state-to-state parental abduction as well.
And so we're here today talking about law enforcement in family law cases and how those two things interact with each other. Emily, can you tell us what is a parental abduction generally?
A parental abduction, I guess there's two different ways you can define parental abduction if you're looking at it in the context of a custody case or you're looking at it in the criminal context. And so people use the term pretty loosely in family law, parental abduction, when one parent might withhold a child from another parent, either for a small amount of time or, a major kidnapping where one parent never sees the child again. And then you have the criminal context, of course, where it's actually, a criminal prosecution for abducting a child from one parent.
And there's actually a criminal law that's in the same chapter as the kidnapping laws in Nevada. Is that right?
Yes.
But it's a separate law in and of itself about parents taking children, specifically from the other parent that would have some sort of parental right over the child?
Yeah, so in the child custody context, if one parent has abducted the child, there's a presumption against that parent not having even joint custody of the child. So it can come into a child custody case pretty frequently if allegations of abduction, kind of soft abduction, where there's not been a prosecution for it. But then there's also lots of family law statutes that have to do with parental abduction, such as obtaining a pickup order or a child custody warrant. If you have a child that's needs to be returned from one parent to the other that's been abducted, even in that civil context. And then we have international laws, treaties between countries that deal with returning a child from one country to another that's been abducted internationally.
So, from your perspective in the courtroom, the family court, when do you see somebody like John come into play, a police officer in Las Vegas? How is their role entering into the family court world?
I don't see it too often, so maybe that's a better question for him on what his role has been in historically dealing with abductions in family court.
Yeah, John, what if any, role have you had in family court?
In the 18 and a half years I've been with LV and PD, the first 11 of those were working patrol. And patrol is where you're going to get the phone calls. The mom or dad didn't return the child, or I'm trying to get a hold of one parent, I can't get a hold of them. It doesn't happen that often. I think I was, before we started talking, I've been to family court or subpoenaed one time in a family court case, and it happened to do with parental abduction. And I had to go in and explain as to why I didn't feel it was parental abduction. And the case revolved around a non-married couple who had a child, and the father had the custody for a weekend or the time, for the time he was supposed to have them. And then at the end, wouldn't return the child. Wasn't at their normal home. Was at a hotel. Not really communicating with the mother of the child. And obviously, once police get involved and officers start calling, cell phone numbers, they're going to pick up and answer questions. And first of all, I make sure the child safety is always first. And then you start looking at were there any other cases in the past? Is this a frequent thing that happens, or was this just maybe the mother and the father had gotten some kind of argument? There was some kind of spiteful am I going to give the child back? But at some point in time, he ended up a couple days later giving the child back to the mother. But it still went to family court, and I had to go in and explain. But like, it doesn't happen very often. I'm sure you hardly ever see police officers in uniform on duty testifying on a family court case.
Yeah, not so much. And we also have, in Nevada at least, the Attorney General's office has a special division that deals with parental abduction. And so whenever, the majority of times I've had to deal with trying to retrieve a kidnapped child from another parent, the Attorney General's office has helped effectuate that, even in the role of getting court orders for a custody warrant to retrieve that child, but also in investigating and facilitating the retrieval of the child physically from the other parent. So that's generally the law enforcement arm that I deal with as a family court practitioner in retrieving abducted children from one parent to the other.
And is that the office of the Children's Advocate for Missing and Exploited Children that's in the Attorney General's office? Is that what that is?
Yes, yeah.
Okay.
Yeah, there's a specific division, and they deal with abducted children generally, but even parent-to-parent abductions go through that office as well.
And ultimately, child abductions aren't the only way that law enforcement could be involved in a family court case, I imagine, right? Like there's standbys that occur, civil standbys for police officers coming out when one person is potentially moving out or doing a child exchange. Is that something that you've ever seen, John?
Yes, it has. I mean, often that's probably one of the most often calls that we get as law enforcement doing a civil standby when one parent's trying to move out. Typically, it's after there's a protection order that's out, and you have to go and you have to. They're always instructed to call the police, ask for a civil standby. It could be for moving out. It could be for custody exchange as well. There's typically been accusations in the past of violence or arrest for domestic violence. So literally, police are just there to keep the peace, to make sure that a lot of those hurt feelings and things that happened in the past don't rear their ugly head during those child exchanges or move out periods.
What does that sort of thing look like from the perspective of an officer and your role?
So it just depends on what it is, right? You've got the case where the parents don't have a custody agreement, but they've had like a makeshift word of mouth general agreement, where they say, hey, you're going to get them on these days, and they get them on these days, and then some type of a fight happens, and the parent shows up to pick the child up, and they don't want to give the parent back. Give the child back. Our role is to show up, and Metro's policy is it's a civil matter. We can't force one way or the other. But on the calls that I've been on, I'll typically look to see if the parent has the court case that stipulates what days and times they have the child. And then I will go, typically it's at a home, knock on the door if there's a parent outside in a vehicle, and explain to the other parent, hey, this is your court order, that your husband or wife's here, or your ex-husband or wife's here to pick up the child. It's technically their time. I can't force you to, but I would tell you probably need to. And if you don't, I usually have to do a supplemental report and send that to the family court. Many times that does work, and they'll be okay. I don't want to get law enforcement involved. But I've also had times when it doesn't work. Like I'll handle it in court. Do whatever you have to do.
Can I follow up on that? One piece of advice that I like to give parents who anticipate that there's going to be struggles where they might have to call in the police to effectuate an exchange when you're getting a court order. So it's quite common for people to get court orders that might say week on, week off. They just alternate weeks. Well, as a police officer, when you show up to enforce that, you don't know which week it is, right? True. So if you're a parent who thinks that you might need to call in the police to enforce a specific schedule, you can get schedules that anybody can read them and know exactly what day it is. So if you have something that says this parent gets the first weekend, third weekend, and every other fifth weekend, and it's defined by the first Thursday in the month, something like that, then the law enforcement can look at that order and know, okay, today is January 5th and it's a Thursday, that means it's absolutely mom's time or dad's time, instead of something that's a little vague, like an alternating schedule, where you don't know unless you know the history of the schedule.
That's a great insight. What about domestic violence calls? How are domestic violence calls handled when you have family that lives together?
So, this typically, obviously, when officers go out, one of the first things that we do is we separate both parties. As long as there's no active violence going on, if it's just one husband or wife or boyfriend or girlfriend with children in the house, two officers get there and usually separate the parties, make sure the children are safe. Unless the children are witnesses, I try to keep them away from the information that the parents are sharing with the officers. I usually tell them, hey, go to a room, watch a movie, unless they're witnesses. And then you just, you get both sides of the story and try to develop probable cause. You look for injuries. I try not to just use one parent's word against the other. I really want to have evidence, other witnesses outside of the family. Kids are great witnesses. Typically, kids aren't going to lie to the police, but obviously the parents have to give permission for you to talk to their child. But kids are always good witnesses if you really need them to be. And then once you develop, if there is probable cause, I try to keep everything out of the sight of the kids. If I'm going to arrest one party or the other, sometimes that's unavoidable, and you're arresting one of the parents, and the kids are screaming and crying, and it's just a terrible scene. That's typically how those calls are handled.
And now, under the law, if you do develop probable cause that one parent has battered another parent, you have to arrest that parent?
Yes.
There's no discretion on your part as an
No,
officer?
absolutely not.
Emily, as far as a family law practitioner, what do you see after this sort of thing occurs?
In domestic violence?
Yeah.
I mean, the difficult thing is that, how law enforcement handles domestic violence and how the child custody courts handle domestic violence. Again, just like kidnapping, we have a presumption that if someone has committed domestic violence, that they should not even have joint physical custody. And so it comes up in child custody cases all the time. And if someone has been convicted of domestic violence, obviously that makes it much easier because that meets the standard. That's a higher burden of proof than we have in the custody case. But it doesn't have to. You don't have to have been convicted of domestic violence in order to meet the child custody burden. And so it comes in a lot of times, even when there's been a situation where someone was not convicted of domestic violence. And so then the police records of what happened, or maybe no police were called at all, and there's photos. It's a very frequent issue in child custody cases. And I mean, it's often a reason why someone would be fighting for custody of a child.
I imagine so. When it comes down to post-domestic violence situations or in the heat of this and courts get involved, we have some questions that have come in regarding what is the difference between a no-contact order and an order for protection against domestic violence. Is there a difference?
Yes.
And what is that?
So a no-contact order is a civil order in family court. If it's one in family court, they have them in other contexts too. But if it's a civil no-contact order in a child custody case, then it has civil sanctions in that case if you violate it. An order of protection has criminal consequences if you violate it.
That's right. So in the criminal context as well, I think that if a domestic battery case gets started and you arrest somebody, they come into court, the judge could order a no contact order at that time, and it would be similar, right? It would potentially affect, as far as civil contempt time for violating it, or potentially affect their custody status in the case. The judge could throw them back into custody if they have contact with the alleged victim in the case.
That's so the interesting thing is you can have no contact orders in a criminal case. So if someone's being prosecuted for domestic violence or sex abuse or something, they can have a no contact order in the criminal case during those proceedings or afterwards. But in the custody case, those two cases aren't linked up. So you could have a child custody case where someone has an order saying that they have custody of that child, and then a criminal case that's issuing no contact orders between the person who has a child custody order and they don't always reconcile. It's actually a big problem if those two orders aren't reconciled between them as to which, because they're equal authority, a family court judge and a criminal judge in the district court here, they have equal authority. And so which one is supposed to follow the other when those orders conflict?
And how do you decide? How does that shake itself out?
That's a very good question.
There's a question that's come in about how family court and criminal court judges deal with a parent who is only supposed to talk about the children but abuses that right and instead tries to discourage or intimidate a witness from testifying in a criminal case, which could be similar in this sort of situation, right? If there's a no contact order with the adverse party, which is one of the parents that was battered in a domestic violence situation, and then there is a court order that says from the family court that they're supposed to communicate about the children, right? What would that look like in the family court?
I mean, that's again another conflict between the two different courts that could come up. I mean, you could conceivably have an order requiring communication in family court and an order prohibiting communication in the criminal court. And again, they have equal authority between them. And I mean, I've had cases where this has come up, and I only practice in family court, so that's where I'm arguing those issues to the family court judge in my practice. But I think that the judges really need to work together. There really needs to be some mechanism where the family court and the criminal court can coordinate to make sure they don't have inconsistent orders.
Right. And then on top of it, if somebody is trying to intimidate or dissuade a witness or a victim of crime from testifying or producing evidence in court, that itself is a felony crime. And they could be arrested for that, right, John?
Absolutely.
And is that something that is taken seriously here in Nevada?
Yes, absolutely. So, going back to the temporary protection order, those violation of that is treated just like domestic violence. A violation of a TPO is there's no discretion. If you have probable cause, you will make the arrest. If the adverse party is not there, you have to at least take a crime report. These cases, when it comes to law enforcement, the investigative arm of this is very, very important. It's very important to get it right, because if you don't and you leave, I've been on calls where you've been to a domestic violence call, you've made an arrest, and then months down the road you show up and it turns into a domestic homicide. So you have to get these things right, and you have to make sure that when the reports need to be taken or arrest needs to be made, that they're made, and that the appropriate investigative arm of law enforcement is notified. If that includes them responding out to the scene and maybe arresting for more charges, I've seen that as well. So this is the most important thing. Is domestic homicide in the Valley is one of the most prolific homicides that we have. So it's just important to get it right.
Yeah, we do have a very high incidence of domestic homicide in Las Vegas. It's something that is higher than a lot of other places and really needs to be taken seriously by our family court, by our criminal courts, in order to prevent it in the first place.
And do you see temporary or extended protection orders as part of that?
Yeah, I mean, the whole purpose of a protection order is to try to prevent things from escalating, to try and prevent anything from happening, whether it's domestic violence or domestic homicide, to prevent it in the first place by limiting or completely restricting contact between those parties. And I think it is an effective tool for that. It's a very effective tool, and it's something that our family courts deal with all the time.
In looking at those two things that we're talking about, a no contact order and a protection order, can you just talk about what the difference is in as far as how you come about getting one?
So a no contact order in the family court is something that if you're involved in a case, in a child custody case, in a divorce case, you can just simply ask for that to be one of the orders, and it's usually done lumped in with other things that are going on, and again, that one just has some civil consequences for violation of it. So it's kind of it's useful, but it's not this huge looming thing. Whereas an order of protection, we actually have very specific rules that govern the procedure for an order of protection, and we have a whole department at the family court that reviews and receives those applications. The police and that department assist people in filling out those applications on their own. It's something that's most often done without attorneys. It's done when people are in a situation where they really need protection right away. And then we have hearing masters at the family court that their job is to hear those cases and make orders in the orders of protection cases. Now we do have rules that if there's also a child custody or divorce case going on that involves those parties, depending on the timing of it, then that case gets heard by the judge who's hearing the divorce or custody case. But if there's no other companion case, then it's heard by the hearing masters that specifically hear those orders of protection cases.
The application process for the order of protection, is that a fast-moving process?
Yes, it is. It's something that can get granted very, very quickly. They're supposed to review them and get them processed, get the other party served as quickly as possible. They set them for hearings very quickly after that in order to review the decision, because of course the decision just to issue it in the first place and serve the other party is it's just based on the paperwork submitted, and so then they try to get the parties in for a hearing as quickly as possible.
So it's like a two-step process. First, the application goes in and there's an order that's granted just on the application itself?
There can be. There isn't always, but most of the time, I actually don't know if it's most of the time, but it's quite often it's granted right away without a hearing, and then there'll be a hearing on it.
And the initial grant of that protection order would be based upon what the judge sees as the merit of the application and what's contained in it?
Yes.
And then at the hearing, that would be an opportunity for both parties to be heard.
Exactly.
Potentially the person who has the protection order against them to contest it and say, this doesn't need to happen.
Yes, and there's rules about making fraudulent claims in an application for an order of protection. There's supposed to be some checks and balances in that system. That's why it's so quick, and that's why there's an opportunity for the person who has the order filed against them to show up and contest it.
So kind of just to bounce back to how we first got here is talking about child withholding. And so how is it determined whether a child is being withheld in violation of a court order as opposed to whether that child is being abducted?
Those can be the same thing. They're not mutually exclusive. And certainly in a criminal context, the criminal court would have to decide a criminal matter. But if it's the family court that's deciding whether or not an abduction has happened, they are only looking at it in the context of the child custody statutes. So we do have a statute for withholding, that if someone withheld a child, you can ask for makeup visitation. So they might look at it just purely in that context of someone get some makeup time. But then, quite often it's looked at in the context of someone asking to modify custody or for a certain custody order to go into place in the first place because of some act or multiple acts that they want the court to consider to be abductions sufficient for that family court judge to determine that that person should not have custody.
Is the family court judge looking at the same statute that a criminal court judge would be looking at for criminal parental abduction?
Yeah, yes. So the abduction statute in the criminal context is the base for what you would analyze an abduction standard in a custody case, but they have two different standards. So, a criminal case has a higher standard than a civil decision on whether or not someone has abducted for the purposes of a custody decision.
That makes sense. And that statute's NRS 200-359. One of the interesting things that I saw when I was looking at that statute, John, is that for a law enforcement officer to get an arrest warrant issued from that statute for that crime, the judge needs to find not only that Nevada is the child's home state, but that a civil court order, so like a family court order, will not be effective to ensure that the rights of the parties are enforced, and it would not be in the best interest of the child to get that civil enforcement instead. Are you aware whether that sort of standard exists anywhere else in criminal law?
I don't.
Getting an arrest warrant.
I don't think so, but it would definitely make sense. When I was a brand new officer many years ago, one of the first things that we're taught, because these calls are highly emotional. We're dealing with both parents who are claiming custody, or one parent who has constantly violated the custody arrangement. And so we are told that it's a civil matter. You can try to talk the parents into working it out. But we're also told is that when we investigate court orders, we have to look at the specificity of it. And very rarely have I ever seen, I can't think of a time, I've ever seen a court order state if so-and-so does not give custody, like basically an arrest warrant from a civil court, if so-and-so, or if the parent does not want to give custody back to the other parent. I've never seen it, but I know that it does exist, and probably for good reason. But it's very rare in my opinion.
I think our laws in Nevada, or I don't even know if it's exactly the laws or just the procedures that have been in place for a long time, but the criminal prosecution of parents for abducting children in Nevada just seems to be just not happen as often in a lot of other places. I think in the 20 years that I've been doing parental abduction in custody cases, I've only seen criminal prosecution of someone handled through the Nevada courts, I don't even know, a handful of times or less. But I used to work with a district attorney's office in California, helping them retrieve children who had been brought from California to Nevada for a period of time. And it was my impression during that time period that the courts, the criminal courts in California, were much more active at prosecuting abductions by parents than the Nevada courts had been.
Do you have any thoughts as far as how that policy is what you're seeing has affected Nevada as opposed to the other jurisdictions you work with?
I don't know. I'm gonna guess that the Attorney General's office, the division that deals with parental abduction in the past, may have set a precedent in Nevada. From my experience, certainly when I was first doing this, there were different people in that office that were very, very hesitant to take action in a lot of abduction cases. That's changed over the years. I think we've had some really good people who got more active, but the precedent of not prosecuting or of really setting a very, very high standard for prosecution of parental abductions, it's something that I think just it got set and at some point has perpetuated over the years.
Yeah, that could be a good question for these attorneys general candidates that are coming up here. I think that one thing I found that was interesting about that statute as well is that it includes something unique, that the prosecutor can, after conviction, recommend that the judge adjudicate the person guilty of a misdemeanor instead of a felony if there's certain criteria that are met, such as the offending parent, hasn't done this before, and that the child didn't suffer substantial bodily harm. It's just interesting all around on what that statute lays out, right? I think that there's some world where, and I believe that historically it was a much harsher penalty and potentially in some places even prosecuted as kidnapping at times. But we've come a long way since then, obviously. As we look to wrap this up, I think that one of the things that I want to just get your guys' take on is how do you see this area of law and police involvement in this area evolving, if at all, or are there things that the state needs to work on here? And it sounds like one of those things might be potentially prosecution of parents who are abducting their children.
Maybe. You certainly don't want to jump the gun prosecuting people who have good intentions.
Mm-hmm.
So we do have some child custody cases that have looked at the intentions of the parent. If a parent goes and moves from state to state, maybe against the wishes of the other parent, but with good intentions, or maybe with a prior agreement of the other parent. The intentions are a huge factor, at least in the custody part of it. So we don't want to get too overzealous in prosecuting parents who have good intentions, but certainly making sure that the criminal court and the family court are acting in sync in how they're handling things, as far as domestic violence or abduction, or anything, or no contact orders in particular. Anything where the two courts with equal jurisdiction need to be working together and consistent with each other.
Okay, so coordination between the courts is what you see as one of the most important factors.
Yeah, for these types of cases.
What about you, John?
From a law enforcement perspective, we only get one. We got to these calls, and we don't know the history of the case, and we're hearing, and I want to call them sob stories, but we're hearing both sides, and from one parent to the other. It's very hard to, without knowing the case history, and a lot of times you don't have that case history in front of you. You have an order in front of you, printed out, typically signed by a judge, but the history is important. I've gone to calls where parents are basically using lawfare against one parent to try to gain custody, and so police officers are there to enforce the laws and the statutes that are passed by your legislators. And so if change needs to be affected, it needs to be that way. If there's a specific problem, bring that to your legislator. Have them bring it up to the legislative session and pass a law, and that way it'll trickle down through the system. But as a law enforcement officer, I mean, I'm a parent myself. I don't want to be involved unless it's obviously for specific acts of violence where the children's safety is always in the forefront, making sure that they're in a safe place and a safe home. But other than that, if it's just two parents fighting, I wouldn't want law enforcement kind of getting in the middle of that fight, because that can just lead to civil sanctions on the officer, potentially being involved, being sued and things like that. So if you want police officers to be more involved or have more of a say, change the statute.
Yeah, one of the things that I saw as well when we look at this statute is I think our legislature did take into consideration a lot of these concerns, and there are exemptions from the criminal liability underneath the parental abduction statute if a parent took the child under an imminent danger of abuse or neglect to that child, or also to protect that own parent from their own physical harm from the other person, as long as the parent reports the taking of the child to law enforcement or child protective services within 24 hours. And so I think that these are obviously extremely volatile situations, and I appreciate your guys' work on it.
Thank you.
Thank you.